Good morning, everyone. I want to welcome you to the ACLU's annual Supreme Court breakfast. Steve Shapiro, our legal director, will give you a little bit of an assessment of where the court has come so far and what we might expect in the coming term. And now I'll hand the program over to Steve.
One is a case that may attract some attention. The City of Pleasant Grove, Utah versus Summum. Summum is a religion. The case arose because the city officials in Pleasant Grove accepted the donation of a Ten Commandments monument. After they placed the Ten Commandments monument in a city park, the adherents of the Summum religion donate to the city their own monument, similarly sized, which contained the 7 aphorisms of the Summum faith. City fathers declined to accept that donation, and the Summum plaintiffs are now before the Supreme Court arguing as a free speech matter, not as a religion matter, that to accept the Ten Commandments and deny their donation of the Ten Commandments monument and deny a donation of their own monument is a form of viewpoint discrimination that violates the free speech clause of the First Amendment. So we'll see what the court has to say about equal access and religious speech under the First Amendment in the Summum case. The other case is a case called FCC versus Fox Television. This has to do with a challenge to the so-called fleeting expletive rule adopted by the FCC following the famous Janet Jackson wardrobe malfunction. It marked a dramatic change in the FCC's past policy and practice. It had never before regarded so-called fleeting expletives as a violation of the indecency rules that govern the airwaves. It's changed its mind after the Super Bowl, and the Second Circuit said that change was itself unlawful because they had not adequately justified it as they were required to do as a matter of administrative law. The ACLU submitted an amicus brief to the Supreme Court in which we agreed with that conclusion, but we also said the case raised a more fundamental issue, and the more fundamental issue had to do with the constitutionality of the indecency rule at all. We pointed out 2 things in our brief, both of which I think ought to be significant to the Supreme Court. One is the arbitrariness with which the FCC has enforced that rule over the years, and the second is the sort of oddity in the modern world now of subjecting broadcasts on television to an indecency regime that do not apply, for example, when those precise same shows are broadcast on the internet, because the internet is beyond FCC regulation, as indeed is cable television. Beyond that, the Supreme Court in recent years has expressed its own discomfort, mostly in the internet context, with the vagueness of the indecency rules and the broad censorial powers that they give to government officials. So we will see how far the Supreme Court is willing to go in FCC and what they have to say about it.